No problem. Okay. Very good afternoon to all of you, and thanks to the organizers of this good and in-depth deliberation, and also to Justice Benjamin, who normally takes leads in such issues. It's a both privilege as well as responsibility to take part in such in-depth deliberation on the issue of protection of the forests. For India, it's an important issue, as is for the other countries. We contribute for about 2% of the world forest, and with a GDP of around 7%, we have the responsibility of balancing growth with protecting the environment. And Judiciary plays a very important role in this. It's not only decides cases, it interprets law, and it takes proactive measures for the protection of the forest and environment. But a judiciary can play a role if there is a firm legislative framework existing in the country. So far as India is concerned, we have in fact such a framework existing. Our constitution itself is the mother of all the enactments. It contains the fundamental right under Article 21, right to life, and by court's interpretation, right to clean environment, that's taken to be a fundamental right of the citizens. Now it has the directive principles of the state policy, that's Article 48A has been incorporated therein, that's by way of 42nd Amendment in the Constitution in 1976, which imposes the responsibility upon the state to preserve the environment, protect the forests. Then we have the fundamental duties which have been incorporated under Article 51AG, whereas every citizen has the duty to preserve, improve, protect forest and environment. So with this mother enactment of the Constitution, we have the laws which have been enacted by the parliaments. We have the Forest Act 1927. We have the Forest Conservation Act, wherein the regime has been provided to conserve the forest. Then we have Environmental Protection Act, which empowers the government to issue directions for the protection of the environment, which are these directions issued under the Act have the statutory force. Then we have Biodiversity Act, we have Wildlife Protection Act 1972. Then we have National Forest Policy, National Environment Policy. So there is a legal framework which is existing. Now the question comes up about gaps. Yes, the gaps are noticed by the courts, because when an in-depth analysis of an enactment is done, the courts come to know about the gaps. And in that process, there is an attempt to fill the gaps, either by issuing directions or issuing guidelines, or it's pointing out, highlighting it to the government. So this is how the entire framework works. Now, after the Stockholm Declaration in 1972, India became the third country in the world to set up a specialized tribunal to deal with the environmental law. It was the first developing country, third country overall. So in 2010, the National Green Tribunal Act was enacted by the Parliament, and the National Green Tribunal is exclusively to deal with the environmental issues that are set up. Now, field of environment and one judge. So that's the minimum quorum is one judge, one expert, they'll sit together and they'll go deep in the environmental issues. And in course of time, in so many years, a large number of cases relating to environment have been dealt with by the court. Then we have the apex court, that's the Supreme Court of India. It also takes up the environmental issues. And in fact, I'll give you with an example, I'll just show how the courts can play proactive roles in protecting the environment. One case that was filed in 1995 in the Supreme Court, that was T.N. Godavaran Thirupad versus Union of India. That was relating to the illegal felling of trees in Nilgiri area. The court could have decided it, finished the matter, but no. The Supreme Court kept it pending. It made it a lead matter. It's still pending. And one by one, the issues are being taken up in that. Either the applications are filed through the applications, the litigants coming up. In that matter, the court then defined forest. What is forest? Says you take the dictionary meaning of it, gave a wide definition of forest. Then, as the matter developed, the issues came up. The court, in that matter, says that if any non-forest activity is to take place in the forest area, then you must have the prior approval of the competent authority. You can't just go there and change the use of the forest, use it, destroy the forest. So that's the restriction which was put. Then it went further. In between 1997 and 2000, it started monitoring the project clearances, whether the projects, they should not affect the forest. It formed a committee, the Supreme Court formed a committee to review the encroachments which were there in the forest to prevent the forest degradation, to ensure that the new projects, they don't come up affecting the forest areas. Then it says that no, without permission, without clearance from the Ministry of Forest, you should not take up such activities in the forest areas. Then it went ahead. The matter was kept pending. It went ahead. Then 2002, a green bench was formed in the court. A green bench exclusive to hear the matter relating to the forest. Then it formed because by that time, so many orders were passed. The issue of monitoring of the directions came up. So it formed a central empowered committee. So that's the committee which looked into the regulation part of it, ensuring that the orders which are passed by the courts are complied with, or examining the intricate issue relating to the forest conservation. Then in 2000, the court said no mining in the forest area and no diversion of the forest for that purposes. Then came 2006, there was a Forest Right Act which was enacted. So the issue of protection of the rights of the tribals, those who are dependent upon the forest, because it's a kind of ecology which work. They are dependent upon the forest and they protect the forest also. So the court came up, Supreme Court says, yes, you protect the rights of those persons who are dependent upon the forest. Then the court took up the issue of the encroachment, removal of encroachments from the forest area. Then after 2011 now, it's issuing direction to strengthen the regime of forest protection. So this is how, what I want to say, this is, take this example of one case. The Supreme Court of India has, in one case, keeping it pending, regulating it, issuing directions from time to time. Whenever the gaps came to the notice of the court tried to fill it up. So by taking the proactive role, the Supreme Court has in fact made the regime of the implementation of forest laws and prevention of the forest degradation and stop forest degradation. Thank you for giving me the opportunity.
Thank you, Justice Srivastava. And finally, for these opening statements, let me turn to Judge Bambang from Indonesia.